Why are Palestinians once again taking their case to the International Court of Justice? What can reasonably be expected from this initiative under the current circumstances? Welcome to Connections, the Arab Studies Institute interview program on current events, policy questions, and new ideas. I'm Mouin Rabbani, and for this episode of Connections, we're delighted to be speaking with Norman Finkelstein. Norman Finkelstein received his doctorate from the Princeton University Politics Department and taught for many years. His many books, including The Holocaust Industry, Reflections on the Exploitation of Jewish Suffering, and Gaza, an Inquest into its Martyrdom, have been translated into more than 60 foreign editions. In 2020, he was ranked the 5th most influential political scientist in the world for the years 2000 to 2020. Norman Finkelstein, it's a real pleasure to welcome you to Connections.
No, thank you for having me.
Let me start by just looking at the motivations behind this initiative. What is the objective of the new International Court of Justice case? In other words, assuming it succeeds, what would it achieve for the Palestinians?
I think first, if you don't mind, you should begin for listeners to sketch out exactly what has transpired to give the relevant background, namely.
Please do.
Yeah. No, I think I would rather you do that. There's a new UN resolution, a new General Assembly resolution.
Correct.
And just sketch out what exactly is happening because it's not been widely reported.
Well, it's a General Assembly resolution that was overwhelmingly adopted earlier this month, December 2022. And many of its clauses repeat what has been asserted by the General Assembly over many years in terms of the right to Palestinian self-determination and condemnation of their violation of their human and national rights. But the additional aspect this time is that it refers to the International Court of Justice for an advisory opinion, not on particular Israeli policies, but on the very legality of Israeli rule in the occupied territories. And it asks what the legal consequences of the status of the Israeli presence are for the status of the occupied territories, if I'm not mistaken.
Well, to begin with, we have to be careful about the precision of language. Mm-hmm. Personally, I do not think it's a well-worded referral to the ICJ. I don't want to get bogged down in pettifogging details that will lose a broad audience. However, if it's not too much trouble, I wonder if either I or you, since it's just 2 paragraphs, if you can read what it states so we can, again, not getting bogged down in tiny details which won't interest the general listenership, but just to analyze, is this a wise strategy? And then we'll look at the bigger picture instead of going from the bigger picture to the tiny minutia, we'll go from the tiny minutia to the bigger picture. So if it's not too much trouble to just read the language.
Yeah, it's paragraph 18 of that resolution. I don't have it right in front of me. I was curious if you might.
I think I do, actually. So let's see. Yeah, it's listed here.
Yes, paragraph 18. Mm-hmm. The General Assembly decides, in accordance with Article 96 of the Charter of the United Nations, to request the International Court of Justice, pursuant to Article 65 of the Statute of the Court, to render an advisory opinion on the following questions, considering the rules and principles of international law, including the Charter of the United Nations, international humanitarian law, international human rights law, relevant resolutions of the Security Council, the General Assembly, and the Human Rights Council, and the advisory opinion of the Court of 9 July 2004. A, what are the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination, from its prolonged occupation, settlement and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character, and status of the holy city of Jerusalem, and from its adoption of related discriminatory legislation and measures? B, how do the policies and practices of Israel referred to in paragraph 18a above affect the legal status of the occupation? And what are the legal consequences that arise for all states and the United Nations from this status? That's a mouth and a half full, but there you have it. Over to you, Norman Finkelstein.
Okay. Let me just get you back up. Good. Again, I should stress I'm a lay person in this matter. However, I have studied the law in great detail.
And if I can interrupt, the reason, or one key reason that I was so eager to speak to you about this issue is because in your recent book, Gaza, an Inquest into its Martyrdom, you devote an entire lengthy and very detailed appendix into examining this very question of an additional advisory opinion from the International Court of Justice. And you lay out in very sharp detail the case for doing so.
The problem as I see it, and the way the resolution or the proposed referral to the ICJ is worded, is then the obvious answer of the ICJ is going to be, we know what the legal consequences are. We know that settlements are illegal. We know that Israel's policies of apartheid are illegal, and so on down the line. And the court will then say that these are matters that have to be resolved in the peace process. So to my thinking, the way it's currently worded, it's so generic, it is so generic that it will enable the court to find an easy way of upholding the law while in effect doing nothing. What I had proposed in the chapter I wrote to the book is that the Palestinian representatives had to focus on the whole peace process, namely the fact that the peace process has ceased to be a peace process and simply a cover not for the incremental annexation of the occupied territories, but a cover for the de facto annexation of the occupied territories.
And why is that relevant in this legal context?
Okay,
What's your reasoning?
Right, the reasoning is, I began with what was the major case before the International Court of Justice in the post-war era. It's been completely forgotten, but the major case was South Africa's occupation of what was called originally Southwest Africa.
Namibia in 1971.
Yeah, it became Namibia. The same parcel of land, but the international community deferred to the name attached to it by the liberation movement in Namibia, as well as as well as the opposition to apartheid in South Africa. So the same issue arose then as has arisen with the Palestinian question since the commencement of the peace process, which is really the peace process, you could say, had the so-called peace process has two elements or two over time has had two temporal elements to it.
And this is specifically referring to the Oslo agreements that commenced
Well,
in
that's what I was going to
1993.
say. Technically, I would say it begins with 1967
Mhm.
because that sets the overall framework, namely the inadmissibility of acquiring territory by war and the recognition of all states in the region. Those were the two parameters for resolving Israel's conflict with its neighboring states. And then, beginning with the Oslo process, there was a more precise wording of the Palestinian side of the case. It was no longer just all states in the region, but the creation of a Palestinian state side by side with Israel. That's the peace process. It was supposed to culminate in the creation of a Palestinian state. At least that was the expectation, the formal expectation of those who entered into the peace process after the when the Oslo agreement took effect in September 1993. Okay, I don't want to lose. I have to always be cognizant of the fact that I'm 69 years old, so this history was actually current for me, and for probably most of your readers, even Oslo is ancient history at this point. So I have to be careful about assuming things that your viewers will not know.
Okay, I'll just interrupt to say that while you make a valid point in terms of at least Palestinian and perhaps also international expectations of Oslo, Palestinian statehood is never mentioned in the Oslo agreements.
Yes, I said formally. Informally, of course, Israel had never had an intention of creating a Palestinian state, and the United States didn't give a darn. Whatever Israel wanted was fine by the US. In any event, South Africa, going back to the League of Nations era, now that really stretches your audience. League of Nations probably summons up either a comic book like the Justice League of America, or it sums up something from ancient Rome. The League of Nations, which was formed after World War I, had created what was called a mandate system. I'm going to just give a little history, but I have to be careful.
Please do.
At the time of World War I, the Bolsheviks came to power in the Soviet Union, and one of their main slogans was the self-determination of nations. And that was very popular as a slogan. It got traction in large parts of the non-European world. To counter the influence of the Bolshevik slogan, now the slogan of the Soviet Union, Woodrow Wilson announced the principle of self-determination of nations. And when the Central Powers were defeated in World War I, they had various colonies. So, for example, Germany had a colony in Southwest Africa. And the League of Nations decided that these territories, which were acquired as a result of the defeat of Germany, the Austro-Hungarian Empire, in World War I, these colonies
And the Ottoman Empire, of course, as well.
and the Ottoman Empire would come under the stewardship, or it was called, the technical term was the sacred trust of the League of Nations. And the League of Nations had an obligation to prepare these territories for the modern world, the strenuous demands of the modern world, as it was called. And one of the territories that was allocated as a result of World War I, the Southwest Africa was allocated to Great Britain, which then transferred the power to South Africa. and South Africa became the mandatory power over Southwest Africa. Now, this may sound like slightly familiar language to your readers because we all remember the British mandate over Palestine. And it was the same process. The British got the mandate of Palestine. It became Great Britain's sacred trust. And South Africa got Southwest Africa. Okay. We're going to do a huge fast forward from the end of World War I to the end of World War II. End of World War II, the United Nations, which is a, you can say formal or informal. I'm not going to go into the legal language because once you start down the path of lawyers, you go down the rabbit hole, you know. So I'm not going to go there. But
for purposes of this discussion, it's a successor organization to the
successor. But believe me, even that, you'll have 10,000 lawyers, well-paid lawyers, arguing on both sides of that question. In any event, the United Nations, the successor organization to the League of Nations, it forms what's called a trusteeship system, which was a continuation of the mandates system. And South Africa then gets involved in this seemingly interminable negotiation with the United Nations as to what is the legal status of Southwest Africa under international law. To bring again, collapsing a story which will twist your mind into several thousand knots, to simplify it as much as possible, South Africa argues that it's under no legal obligation to allow for the self-determination, the independence of Namibia. The United Nations argues, or the overwhelming number of states in the United Nations argues, that South Africa has an obligation to grant Namibia independence and for it to become a self-governing entity. And as I said, it became this interminable legal process with the case going back, and back again to the International Court of Justice. And finally, the court rules in 1971 that South Africa has an obligation to enable Namibia to exercise self-determination, and that South Africa has not been negotiating in good faith. That was the key finding. There are other findings which are also pertinent to the Israel-Palestine conflict, but that's the key finding. You have a legal obligation to enable Southwest Africa, Namibia, to have self-determination, independence, and statehood, and you are not negotiating in good faith to achieve that obligation, your obligation under international law. South Africa says we have no such obligation, and we have the right to annex Namibia, Southwest Africa, or we have the right to annex parts of it. That was South Africa's argument. Now, in my opinion, the crux of the conflict now is that the so-called peace process is being used as a weapon of diversion and deflection, and effectively as a cover for the fact, and here, if I can introduce a new idea to you and to your listeners, I do not think it is legally correct, and I do not believe it serves the interests of justice any longer to refer to those territories as the occupied Palestinian territories. That is an incorrect description of the situation.
And just to
Correct.
interject, Norman, because occupied territories is a legal status.
That's what I'm going to get to
international
right
law.
now. I mean, if you would like to take over, that's fine, but that was what I was going to get to right now. Namely, that absent a peace process, it would be said the territories have been annexed. It's only the so-called peace process that enables apologists for Israel, or those who want to evade their responsibility under international law. It's only the so-called peace process that enables those people and entities to evade their legal responsibilities. It is, and it should henceforth be described as illegally annexed territories, IAT, not OPT, because they're not occupied territories any longer under international law. International law, here for a change, it's very simple. It's not complicated at all. What distinguishes an occupation from an annexation, what distinguishes the two, there's only one thing that distinguishes them. I know 10,000 lawyers are going to start saying, no, there's this and that, but F the lawyers. There's only one thing that distinguishes them, distinguishes the two, and that is an occupation is temporary and annexation is permanent. And if there weren't this fake, spurious peace process to refer to, we would say it's an annexation. It's over a half century. It's over a half century. From 1967 to now, we're heading on 60 years. It's over a half century. It's a de facto illegal annexation of the territories. So, what I think the referral should have been to the ICJ is, what are the legal consequences of negotiating in bad faith an end to the occupation? Because that has become the key issue. I mean, it's been the key issue for obviously a very long time. But, even the other day, President Biden, he said, I support a two-state, solution. I support the peace process. If the court were to rule, if the court were to render an advisory opinion that says these are not negotiations in good faith, these are bad faith negotiations by the United States, by Israel and the United States, these are not good faith negotiations, then the conclusion can only be it's an illegal annexation.
Okay, so let me interrupt you now with a question. If the Palestinians had indeed moved forward as you proposed and obtained the advisory opinion that you suggest they would have achieved, what would be the consequences of such an advisory opinion? And just to put the political aspects aside for the moment, if it had been a legal success, what would that mean?
You have to look at it in the immediate term and in the long term. Mm-hmm. Now, here we can disagree. Of course, we can agree to disagree. For the moment, in my opinion, the Palestine cause is dead. For the moment, it's dead. And no legal opinion in the absence of a mass movement, and I'm not saying this because I'm Rosa Luxemburg, even though I greatly admire her, in the absence of a mass movement, no legal opinion, if it doesn't have force to back it up, means anything. It amounts to, I think Humphrey Bogart said in Casablanca, he said, it amounts to a hill of beans. It amounts to nothing, you know? So in the short term, I don't think it would have any consequences. And we have to bear in mind, there's a certain element that's come into play of redundancy. That is to say, we had a very powerful International Court of Justice advisory opinion in July 2004. The Palestinian leadership, so-called, did nothing with it. We had the powerful Goldstone report condemnation of Israel. The Palestinian leadership not only did nothing with the Goldstone report, but it collaborated with the United States in Geneva to kill the report. We then had, in the last couple of years, we've had extremely powerful statements and reports by B'Tselem, the Israeli Information Center for the Occupied Palestinian Territories, by Amnesty International, by Human Rights Watch, and then by several the major Palestinian human rights organizations, all saying that Israel had created in total or in part, an apartheid regime between the Mediterranean Sea and the Jordan River. So to put it simply, the Palestinians don't lack, there is not a dearth of legal and respectable opinion on its side. So to use the metaphor, it has many arrows in its quiver, many. The problem is it has no bow. It has no movement to make use of these arrows. So at this point, in my opinion, were it to come to pass, in my view, it will never come to pass, but were it to come to pass that the ICJ ruled in its favor, it would just be one more arrow in its quiver. However, if a movement ever emerges, it doesn't hurt to have those arrows. Now, you have to remember, just to give you the most obvious example, we are now more than a century, actually well more than a century, after the Balfour Declaration, okay? We are more than 60 years after the partition resolution. However, Israel still uses the Balfour Declaration and the partition resolution. In any class you take in the Israel-Palestine conflict, in any class, you're going to have the Balfour Declaration mentioned. You're going to have the partition resolution mentioned. So once you have those arrows in your quiver, they can be used, well into the future, which is my way of saying, if they want it in the ICJ, it's another arrow in their quiver. If and when a new resistance emerges, they will have those weapons at hand.
And what would be the specific advantage of this particular ruling were it to come to pass, as opposed to, let's say, the 2004 resolution or these apartheid reports that you mentioned? Is there any specific advantage that this would confer on the Palestinians?
Yes, because the Israelis and their supporters still say it's a legal occupation, and that the only obligation they have under UN Resolution 242 is to negotiate in good faith an end to the occupation. UN Resolution 242 in November 1967, it did not require of Israel a unilateral withdrawal from the territories it occupied in the June 67 war. What it required was a quid pro quo, namely, the Arab states had to recognize Israel, and Israel had to agree to withdraw. And so long as Israel can maintain that it's negotiating in good faith to get mutual recognition between Israel and the Palestinians, so long as it can claim it's negotiating in good faith, it has no legal obligation to withdraw. If it's designated an illegal annexation, then Israel has only one right. It has the only right it has under international law is to pack up and leave. And so it'll put an end to this whole facade of a peace process which justifies and enables the occupation. Well, it's not an occupation, justifies and enables the annexation of the territories. I don't think in the court of public opinion, I don't think that's a trivial thing, because the important point is once it becomes an annexation, once it's deemed an annexation, or as that Selim put it, and as Amnesty put it, it means that half the population between the Mediterranean Sea and the Jordan River does not have the right to vote, does not have its most elementary right, the right to vote. And then we're in a situation, not exactly, but close enough to make the argument in the public. We're in the situation of the United States before the Civil War. We live in a state which is half free and half slave. And as you know, Abraham Lincoln famously said, a state which is a house that's half free and half slave cannot long continue. And so I think it would put in more stark terms the reality. There's one state, the West Bank, Gaza, the West Bank, including East Jerusalem and Gaza, have been annexed. There's one state, and in that one state, approximately, not exactly, but approximately half the population has no rights. It has no rights. I wouldn't even say we should talk about their rights under occupation anymore, because there's no occupation. There's an annexation, and half the population in those annexed territories have no legal rights under international law. They're not recognized. They're not recognized. They have no rights. I think that's a starker and a clearer way of presenting what the current situation is and the foreseeable situation. And I don't think anyone can make a credible argument at this point. I think it's impossible to make a credible argument that given the trajectory of the Israeli governments since roughly 2000, given the trajectory of the Israeli governments since roughly 2000, I don't think anybody can make a credible argument that any outcome approximating international law is conceivable with the governments that have been empowered in Israel. It's not possible. So it's an annexation.
And I was wondering whether you also consider it worthwhile to look at the current composition of the court versus the court that issued the 2004 advisory opinion on the wall, or are these kind of superfluous details given the broader political obstacles that you've been describing?
I would say, look, there were points where the composition didn't matter a lot. Mm-hmm. And you saw that in the International Court of Justice case over Namibia, mm-hmm. where the change of one or two judges resulted in a totally different outcome. There was a decision in 1962 in favor of Namibia. The exact same point of contention, the exact same issue in 1962 came up in 1966, but the composition of the court changed, and it was sort of like Roe v. Wade, and then the Dobbs decision on abortion in the United States changed composition of the court, changed result.
Same question, different answer.
Yeah, same question, different answer. And
how do you see?
But in this particular case, there's no movement, no states. Forget about movement. There are not even any states putting pressure now on the ICJ, the International Court of Justice, is a instrument of the United Nations. There's no states putting pressure on it to resolve the Palestine question. So to my thinking, it's inconceivable that they will even accept the case. Remember, there is 2 stages in any case before the ICJ or the ICC, the International Criminal Court. There's what's called the jurisdiction question, and then the merits, the jurisdiction phase, and then the merits phase. The jurisdiction phase basically means, does this court have authority to adjudicate this question? Does this
And
court
that's for the court to decide.
Yes. Does this court have the authority to render this opinion? And then the second phase is the merits phase. If it has the authority, then which side has merit in the case? I don't think it's going to get even past the jurisdiction phase.
And that's because of the absence of sufficient political pressure on the court.
You have to remember that the whole South Africa case was being played out in the background of a continent of Africa, the whole continent of Africa, taking grave offense at this avowedly white supremacist regime in a corner of Africa, which, whether you were a conservative state or a radical state, there was a level of flagrant moral offense by the system of apartheid that no state could defend it or even ignore it in public. But that's just Africa. Then there's the whole international decolonization movement, the third world movement, the non-aligned movement. I mean, there are so many things happening politically on the international stage, all of which converged on the question of apartheid. In addition, you had a very potent, formidable, intelligent anti-apartheid movement, both in South Africa, and then it found support by the international anti-apartheid sanctions movement.
But Norm, are conditions today that different from those in 2003, 2004, when the Palestinians first?
Well, I was going to get to that.
Mm-hmm.
I'm glad you reminded me. I think it's forgotten when everybody thinks of the Second Intifada, they think about, or they've been conditioned to think about the suicide bombings. The Second Intifada begins, I guess, September 29th, 2000. And what's often forgotten, and you really, even supporters of Palestinians need the memory to be jogged, was the huge, colossal Israeli criminal actions during the Second Intifada. The house demolitions, the targeted assassinations, the torture. It was a very big international story, what Israel was doing to the Palestinians during the Second Intifada. It was at that point that you really had a proliferation of human rights reports on what was going on in the occupied Palestinian territories. True, it begins with the first Intifada in 1987, beginning in December 1987, but it really reaches a peak during the Second Intifada. And I could say, because I have real life experience, it was at that point in time that you start on, say, college campuses to have huge audiences coming out to hear what was going on and what is this Israel-Palestine conflict all about. It reaches its climax a few years later. The ICJ opinion is in 2004, July 2004.
Right.
The climax really is Operation Cast Lead. That's when demonstrations.
2008, 2009.
Right. They reached a peak. Actually, the demonstrations after Operation Protective Edge in 2014, which was much worse than Cast Lead, they were smaller. It already had reached its peak. But that was roughly the era when the ICJ rules on, not rules, renders an advisory opinion on the legal status of the wall that Israel was building in the occupied Palestinian territories. So the situation is very different. It's just forgotten what was the context, the political context of that ICJ opinion.
Yes.
And I'm not correcting you. I would just want to put in perspective that particular UN resolution, General Assembly resolution, from which you quoted.
Mm-hmm. Of December 2022.
Right. And you said it got overwhelming support. I can't say that's entirely accurate. The support was closer to the Zionism is racism resolution, which was about 90 states, but a huge number of abstentions. Mm-hmm. And in this particular case as well, there were a huge number of abstentions by all the Europeans, but not only the Europeans.
Correct.
So it wasn't a great showing in terms of support for the resolution. And all of that resonates with the court, those facts.
So we need to see not only the court as in fundamental respects a political institution, but more importantly, as one that is very aware of the political environment in which it conducts its business.
Yes, look, I guess for those of your listeners who are not familiar with the court, it's representatives from states. And whatever the case before the court, it's to my recollection, you will never see a representative from a state voting against its own state, whatever the case may be. Whatever the case may be, it just doesn't happen. There was one strange part of the South African case, which it's worth mentioning. The main supporter of South Africa was this British guy named Fitzmaurice, and he was the most revolting reptile. He was like in my U.S. Supreme Court, Antonin Scalia. He was smart. He knew the law, but he was so obnoxious. I mean, I want to throttle him while I'm reading his opinions. Oddly enough, so the court was lined up, the old-time colonialists on one side, and then the anti-colonialist third world countries on the other side. That's basically how the court lined up during the South Africa case. Oddly enough, the main opposition to Fitzmaurice came from the American judge, Jessup, who was actually a decent guy. But at that point in time, in the 60s, the US was hell-bent on dismantling the old colonial system and replacing it with itself.
Right.
So it wasn't altogether surprising that the US would be arguing the so-called anti-imperialist position. But when it came to the Palestinians in the wall case, the one country which abstained was the
The
United
United
States.
States, correct.
So, I would say my conclusion would be, number one, the focus of the resolution should have been on lifting the veil of the peace process to expose the stark reality of, as B'Tselem put it, a Jewish supremacist state from the Jordan River to the Mediterranean Sea, a Jewish supremacist state in which Palestinians overwhelmingly, I'll leave aside the question of Palestinians inside Israel, but Palestinians overwhelmingly have no rights. So it's an annexation with about approximately half the population rightless. And that to me would have been an important victory. But for the court to now reiterate, settlements are illegal, annexation of Jerusalem, illegal, and 10,000 other things which Israel does, each of them discreetly illegal. What are the legal consequences of settlements being, well, we already know that. The ICJ decided that in 2000, in its 2004 opinion. It said the settlements are illegal. What they should have focused on, in my opinion, is the question of the bad faith negotiations. That you can't keep saying, we're negotiating, we're negotiating. You're not negotiating. There are no negotiations going on. And it's exactly for the reasons that were spelled out in the ICJ opinion on Namibia. They said, you can't have agreement if you don't agree on what the end point is. There can't be negotiations if you don't agree on the end point. There has to be agreement, consensus on the end point. And Israel does not accept the end point. The end point is international law. And international law includes the right to self-determination and independence of the state of Palestine. But if you don't have agreement on the end point, then these are not negotiations.
They're a fiction.
They're a fiction.
Norman,
And the court could simply have said that these are not good faith negotiations. And just as in the case of South Africa, you can't use the claim of you're negotiating, you're in the peace process, because there's no peace process.
Norman Finkelstein, thank you very much for sharing your legal as well as political expertise and insights with Connections. Thank you very much.
You're welcome.